Hi, I'm Todd Smithline, and welcome to Smithline Training's Indemnity and Software and SaaS Agreements. First, a quick disclaimer, Smithline Training LLC is not a law firm. And while we'll be talking about legal topics today, we're not providing legal advice. Likewise, if you attend one of our roundtables or otherwise interact with us, no attorney-client privilege is created. And finally, as always, consult with a lawyer for your specific legal questions. Now, we follow a two-step training approach here at Smithline Training. First, you watch the episode as you're doing now, and then we invite you to attend one of our roundtables. The roundtables give you an opportunity to ask questions about the episode you're watching and share best practices with other program participants. We hold those roundtables both online and in person at our offices in San Francisco, so we hope you'll join one of the roundtables to discuss today's episode. If you have questions, complaints, feedback, you can always reach us at help@smithlinetraining.com. Now, we provide a tool with each episode, and today's tool is our indemnity worksheet and checklist, and you can download that right here on the site where you're watching the episode. So what's our lens or perspective for today's presentation? Well, today we'll be talking about indemnity in the context of an enterprise software or SaaS agreement. So we're talking about a situation where a customer is coming in and spending tens, maybe hundreds of thousands, maybe even millions of dollars to procure a software solution or a SaaS solution. And if they're going to negotiate that enterprise license agreement or that SaaS subscription agreement with the vendor, you can bet that one of the provisions which will come up in that negotiation is the indemnification clause. In fact, indemnity is typically one of the most heavily negotiated provisions in those agreements. So as a vendor, how should you think about those requests that you get from your customer to grant indemnity? That's what we'll be talking about today. And customers, we're also going to have some tips for you in those negotiations. So what specific topics are we going to cover today? Well, today we'll look at the what, the when, and the how of indemnity. What is indemnity? When is indemnity appropriate? And as part of that, we'll introduce you to the 4 fundamental principles of indemnity, at least as we see it, and we'll apply those principles to common customer requests for indemnification. And finally, we'll discuss the how of indemnity. So how do you draft these clauses? We'll give you some drafting tips, and then we'll talk about the important and sometimes tricky interplay between the indemnification provision and the limitation of liability. And after those points, we'll also have some questions and answers from our first indemnity roundtables. So let's get started. So what is indemnity? Well, indemnity in its broadest conception is a contractual risk allocation mechanism. And broadly defined, indemnity can really be any promise between two parties of the contract where one party agrees to save or indemnify the other against the legal consequences of the actions of that party, the other party, or even a third party to the contract. But in the context of a software or SaaS agreement, indemnity usually means something a little more narrow. And it means that the vendor will defend the customer against lawsuits brought against the customer arising out of the contract. And typically the vendor will also pay the damages of that lawsuit. And we'll be talking about when indemnity is appropriate and why in a minute, but for our purposes today, we're really talking about indemnity as a promise by one party to stand between the other party and a lawsuit brought by a party outside the contract. Okay. The second general observation we want to make about indemnity is that it is defined mostly by contract. Now, there are indemnification statutes, and if you're negotiating indemnity clauses, I'd recommend you look at the statutes that apply in the jurisdictions that govern your contract. But for the most part, those statutes are superseded by the contracts themselves. Here in California, the law says that in the interpretation of a contract of indemnity, the following rules are to be applied unless a contrary intention appears. Likewise, courts in California will use general rules of contract interpretation when interpreting an indemnity clause. So for the most part, the parties' obligations and rights with respect to indemnity are going to be defined by the 4 corners of the contract of the agreement that they're negotiating. The last general observation we want to make about indemnity is that it's highly interconnected with other clauses of the agreement. a software agreement or a SaaS agreement is going to have a number of other clauses which seek to identify problems that could arise during the term of the contract and tell the customer exactly what's going to happen when those problems arise. You have warranty clauses, you have support clauses. If we're talking about a SaaS agreement, you might also have an SLA. So the first thing to understand here is that the indemnity is not alone in being a clause under the contract that's identifying problems that might arise and deciding who's going to be responsible for them. Secondly, the negotiation of the limitation of liability clause of the contract will often turn on issues regarding the indemnity, how we're going to treat the indemnity. So indemnity is fairly unique in this sense that you need to think of it in the larger context of the rest of the provisions of the agreement. And in fact, it's this interconnected nature of indemnity that makes the question of when indemnity is appropriate all the more important. So we've talked about what is indemnity. Now let's look at this question of when should you indemnify? And we think of indemnity as really a special case under a contract. It's an unusual contractual provision because, unlike other provisions of a contract which deal with the obligations and responsibilities of the parties within the contract, indemnity is dealing with something coming into the contract, a third-party claim from outside the contract. So because of that, we think it's only appropriate in very special circumstances. Yet, customers, as you well know, will ask for indemnity for all kinds of claims. So given that as a vendor, how do you think about those customer requests and how do you decide when you want to grant indemnity? Well, we think it's important to take a step back and establish the fundamental principles of when you think you should indemnify and then apply those principles to the individual customer requests. So we've gotten you started here with what we call our 4 fundamental principles of indemnity. What are they? Well, the first principle is that we think indemnity is appropriate for third-party claims that are foreseeable. The second is that it's appropriate when the indemnitor is the party between the two parties who's most likely to be responsible for that claim. Third, the indemnitor should be the party best positioned to defend the claim. And finally, there should be no better other contractual mechanism to deal with this claim. Let's break that down a little bit. First, I said third-party claims that are foreseeable. If the claim isn't foreseeable, it's hard to evaluate it as appropriate for assigning responsibility to one party in advance. Likewise, if it's not a third-party claim, there's probably already a better way under the contract for dealing with the problem. Perhaps it's best dealt with as a warranty claim, maybe it's best dealt with under support or SLA, or even finally as a breach of contract claim. Secondly, I said indemnity is appropriate when the indemnitor is most likely to have been responsible for the claim. Remember that the indemnitor is assuming responsibility for the claim in advance, so it really should be of a type that's necessarily attributable to the conduct or the technology of the vendor. Third, indemnity is appropriate when the indemnitor is best positioned to defend the claim. The indemnitor is almost always the party assigned with the responsibility of bringing the defense, so we really want that to be the party who through control of the facts, personnel, and technology is best positioned to bring a good defense and get a good outcome. Finally, our fourth principle was that there should be no better contractual mechanism to address the claim. As I mentioned before, contracts have all sorts of provisions which anticipate problems which might arise and how the parties want to deal with them. We have warranty, we have support, we have SLA. Indemnity is really appropriate when none of those provisions is better positioned to deal with the problem. So now let's apply those 4 principles to some common indemnification requests from enterprise customers. The first request that customers will make, and probably the most common, is to be indemnified against IP infringement claims. Commonly, they will also request to be indemnified for breach of contract, for negligence and willful misconduct, and finally, for data security breach if we're talking about a SaaS context. So let's talk about each of these individually and apply the 4 principles to each. So the customer, let's assume a software contract here, and the customer says, I want to be indemnified in the event that I get sued for patent infringement based on using your software product. How should the vendor think about this request? Well, are we talking about a foreseeable third-party claim? Yes, we are. Is the indemnitor most likely to be responsible for that claim? Yes, the indemnitor either created the technology or is controlling the technology, but as between the customer and the vendor is certainly best positioned to deal with an infringement claim arising from the technology itself. Is the indemnitor best positioned to defend the claim? Again, the answer here is yes. As I said, they control the technology, they have access to the inventors, they're the party who's going to be best positioned to go into court and explain why this allegation of infringement is untrue, or to deal with making changes to the product that might be necessary to avoid the infringement. Finally, is there a better mechanism to address a third-party claim of intellectual property infringement against the customer? And here the answer is not really. It's not uncommon for customers to ask for a representation and warranty that the product they're buying does not infringe. But it's not clear that a breach of that rep would necessarily get the customer a defense against a third-party claim of infringement. The customer's going to have to take a couple steps there to get from the breach of the representation to an obligation by the vendor to actually defend the third-party claim. And so for that reason, we say there really isn't a better contractual mechanism to exist an intellectual property infringement claim. So is IP infringement a good candidate for indemnity? Yes, we think it is. The second customer request was to be indemnified against any breach of contract. Now, as we just discussed in the first and fourth principle, indemnity really doesn't make sense for claims directly between the two parties. We already have a better mechanism for that, that's breach of contract. But what if the customer's already seen a video like this and they say, okay, vendor, I understand you're not going to indemnify me against any breach of contract, but what if I'm using your product and you breach the agreement and your breach causes somebody to sue me? Won't you stand between me and that third-party claim? Well, how should a vendor think about this request? Is it a foreseeable third-party claim? Well, here the answer is not likely. And the reason is that it's going to be very hard to draw a direct line between whatever it is that the vendor did that constituted a breach of that agreement and the claim coming in against their customer. Imagine a scenario where the vendor is providing a SaaS service that's a storage solution. And their customer runs a chain of pet food stores, and they're uploading inventory data into that system. And maybe that pet food chain also has franchisees, and maybe they're so good at managing inventory data that they're also managing inventory data for third-party companies. So the customer has their own complex set of relationships set up, and the customer says, look, your service went down, that constituted a breach of the agreement. I'm now having trouble with my own customer and partner relationships, and I want you to stand between me and those problems. The problem for the vendor is that, again, the line between what the vendor did that constituted a breach and those claims coming in against their customer is just too difficult to draw with the level of certainty that would be required for the vendor to say in advance of all that, yes, customer, no matter what those claims are, I will defend them and I will pay those damages. So is there a foreseeable third-party claim here? Not likely, or not clearly enough to the point that the vendor is going to feel comfortable taking responsibility for that in advance. Is the indemnitor most likely to be responsible for those claims? Well, if we can't identify the claims with any particular specificity in advance, we don't really know which party would be most responsible for them. And would the vendor be in the best position to defend? Again, the answer here is it's really unknowable in advance, but we can certainly think of circumstances where the vendor would not be best positioned to defend, and that's simply because the vendor is not in privity of contract with the customer's own customers or partners or franchisees, and therefore, if the vendor has to deal with that lawsuit, it will not have the benefit of governing law provisions or arbitration provisions or limitations of liability with those parties. Finally, is there a better mechanism to address this kind of harm? Well, yes, absolutely. It is called breach of contract. And if the customer feels that the vendor's breach caused and directly the harms, those third-party lawsuits, the customer can always plead those lawsuits and those damages as part of what they're asking for in compensation for the breach. So yes, there is another better mechanism than indemnity to deal with this request. So finally, is breach of contract a good candidate for indemnification in a software SaaS agreement? We think the answer is no. So what if the customer requests to be indemnified against third-party claims allegedly arising from the negligence or willful misconduct of the vendor. Do we have foreseeable third-party claims here of the type that are sufficiently clear that the vendor is going to agree to be responsible for those claims in advance? And we think the answer is not likely. Two things to note here. The first is that negligence and willful misconduct are really tort concepts. So there's already an awkward fit trying to bring them into the contractual context. The second point is that almost any failure by the vendor to perform under the contract could be characterized by that customer as arising from the vendor's negligence. So for those reasons, we don't think that third-party claims being brought against the customer allegedly arising from the vendor's negligence or willful misconduct are really claims of the type that the vendor should feel comfortable taking responsibility for in advance. So if we can't really define these claims, can we say with certainty that the vendor is most likely to be responsible for them? And the answer there is no. It's really unknowable who would be responsible for those claims. Likewise, can we say that the vendor will really be the party best positioned to defend these claims? Well, if we don't really know what these claims are, and we think there might be a very tangential connection between the vendor's actions and these third-party claims being brought against the customer, no, we can't really say that the vendor would necessarily be best positioned to defend those claims in advance. Finally, does a better contractual mechanism exist to address third-party claims allegedly arising from the negligence or willful misconduct of the vendor? Yes. Of course, the customer can bring a claim for breach of contract, and they can also bring a claim in tort. So is negligence and willful misconduct a good candidate for indemnification under a software SaaS agreement? The answer is no. But there is an important exception here. And you might have been thinking about this while I was going through that list. There is one time where we think it does make sense for the vendor to agree to be responsible for claims arising from their negligence and willful misconduct. And that's when we tie the negligence to personal injury or tangible property damage. If the customer is willing to do that, then we do think it makes sense for the vendor to consider making the indemnification, because now we have connected the negligence, or we'd actually recommend, if you're the vendor here, you limit that to your gross negligence, but we've connected the negligence to the alleged harm, and now the vendor can sort of wrap their head around being responsible for those claims, because we know that the vendor would most likely have been responsible for them, and we know what those types of claims are, and that's something that most vendors will get comfortable indemnifying for. This is a common request when the vendor is going to be coming on site and performing professional services. The customer is afraid that the vendor is going to string together a bunch of extension cords, and one of the customer's employees is going to trip, and the customer is saying, look, I want you to indemnify me against that type of personal injury or property damage arising from your negligence. Again, as the vendor, be careful, try to limit that to gross negligence, and absolutely make sure that we're talking about tangible property damage and not data. Okay, the last typical customer request for indemnity in a software or SaaS agreement, but particularly in a SaaS agreement, is going to be for data security breach. So, SaaS vendors, what do you do when the customer says, I'd like to be indemnified for third-party claims against me as your customer resulting from a data breach? Well, are these foreseeable third-party claims? The answer here is yes, they are. Is the indemnitor most likely to be responsible for that claim? Well, the answer is maybe. The vendor does control their own systems, so if there's a security breach on their systems, it's most likely the vendor who is responsible. With that being said, the vendor does not really control the total scope of risk arising from the security breach. If we think of the example I gave before, which is a SaaS company, and they're storing their customers' data, and they have a particular customer, which is this chain of pet food stores. And as I said, that chain of stores is storing data on behalf of themselves, on behalf of their franchisees, and maybe even on behalf of third-party customers. And it's really the customer, the SaaS vendor's customer, who's deciding what data is being stored and how sensitive that data is, and what the risk profile is if there's a breach of that data. Secondly, no network system can ever be 100% secure. So the question of responsibility for data breach is a complex one. It can be a complex technical question. And the question of who's really responsible here and who created or was best positioned to control the harm is also complicated. So here we say maybe the indemnitor will be responsible. Likewise, would the indemnitor be best positioned to defend the claim? The answer here is also maybe. The vendor knows its systems the best, but the claims are being brought against the customer, and it's the customer, as I mentioned before, who's in privity of contract with those third parties. So it's the customer who had the opportunity to set up in its own contracts limitations of liabilities or other provisions to deal with a circumstance like a data breach. But because the vendor itself doesn't have privity of contract with those third parties, it may well not be the best positioned party to defend those claims. Finally, does a better mechanism exist to address these claims? Well, the answer is that there might. If the vendor and the customer have agreed to a set of security provisions, the vendor may already be obligated to give notice of the security breach and to do some remediation of the breach, such as to pay for third-party credit reporting or other costs suffered by the customer or the customer's customers. So there may be some other provisions of the agreement which are already dealing with what happens if there is a data breach. So when we sum it all up and we ask the question, is data breach a good candidate for indemnity? The bottom line answer here is maybe. So what's a common result when a SaaS enterprise customer asks the vendor to be indemnified for data breach? Well, typical results will include a vendor agreeing to indemnify for data breach, but then imposing some very important restrictions. The first is that the vendor is only going to indemnify for those claims arising from unauthorized data disclosures resulting from the vendor's breach of its own obligations under the contract. So the vendor in this case would have a set of security promises that it's going to make, a series of statements about how it's going to operate its systems, and what the vendor is saying is that if I don't do the things I promised to do, and it was my failure to take those actions that resulted in the breach, then I will be responsible. That's the first restriction that the vendor typically places. The second is that the vendor will typically say, even still, there is going to be a cap on overall liability for the data security breach. So we've talked about what is indemnity, and we've talked about when is indemnity appropriate. Now let's talk about the how of indemnity. And we want to start with some indemnity drafting tips. What you see in front of you here is a typical indemnity provision from a software license agreement. Now you'll see there's a lot of text on the screen here, but don't panic, you have this in your tool. So if you haven't already done so, you might want to download that tool and have it in front of you as we go through these tips. And we've got 7 tips for you sprinkled throughout this clause. Quick note first on these tips. You really want to carefully consider your exact circumstances when you're drafting an indemnity clause, as well as what's going on in the rest of the contract. So we're going to give you these 7 tips, and hopefully they'll help you along the way, but these are really just some general tips to consider while you're drafting your clause. So our first tip goes to the very start of the indemnification clause, and this is the lead-in language that sets forth the indemnitor's obligations to grant the indemnity. And the typical language, as you see here, says the vendor will defend, indemnify, and hold harmless the customer from and against the claims. Tip number 1 is that each of these words actually has a slightly different meaning, and you should know what those words mean when you're drafting this clause. To defend is an obligation to defend a claim and pay the cost of the defense, but it's not necessarily an obligation to pay damages arising from the claim. To indemnify is an obligation to protect against losses, but it's not necessarily an obligation to actually defend the claim. Although I will note here that under California law, and we have the civil code site for you, in an indemnification, the indemnitor is in fact required to either handle the defense or pay for the defense. But outside of California law or outside of a provision in the agreement saying that you will in fact defend the claim, just be aware that if you only use the word indemnify, it does not necessarily mean that the indemnitor is required to defend the claim. Finally, hold harmless. Many courts treat hold harmless synonymously with the word indemnify, but other courts will treat hold harmless simply as a statement that the parties agree to release each other against certain claims. So again, each of these words, defend, indemnify, and hold harmless, has a slightly different meaning. So how should you structure that first sentence? How should you structure your indemnification clause? Well, we would suggest you pick one of two structures. The first structure is the typical structure you see here, which simply says all three words: the vendor will defend, indemnify, and hold harmless customer against the claim. Now this we think of as being customer favorable because it's clear that the vendor has to defend the claim and pay for those defense costs, and also that the vendor has to indemnify or pay all damages arising from the claim, whether those are damages payable to a third party or maybe even possibly direct costs that the customer suffers throughout the claim. The second structure says that the vendor will defend the claim and then will pay any amounts awarded, or if you're the vendor, you'd like it to read finally awarded, in the claim or in a settlement. And we call this the vendor favorable approach because while the vendor is clearly obligated to defend the claim, and while the vendor has to pay all third-party damages, whether arising in settlement or in court, with this formulation, the vendor is not necessarily going to have to pay losses or costs suffered by the customer. So these are the two formulations. Again, we'd suggest you pick one or two depending on your circumstance. In terms of structuring that all-important first statement of the indemnity. Our second tip goes to the identification of who is the indemnified party. Here you'll see language which says the vendor agrees to defend, indemnify, and hold harmless customer, its affiliates, and each of their respective officers, directors, employees, and agents. So these are all basically people who are either the customer themselves or directly legally related to the customer. But sometimes you will see a customer request to expand that litany. They might ask to include their own customers, their own licensees, their partners, or other parties. And our tip here for the vendor is that you really don't want to do that. It's problematic to include those parties because they're not parties to the contract. And because of that, it's not going to be clear under what terms they can enforce the indemnification. And it's also not going to be clear what happens if you work out a solution with your customer and that solution is not a solution which makes those other third parties happy. So are actions that your customer takes going to be held as binding upon those other third parties who may be seeking protection under the indemnification? So for all those reasons, we would recommend as a vendor that you indemnify only the other party to the contract and their really immediate parties and nobody else outside the contract. Our third tip goes to the claims themselves. So what are the claims that the indemnification is going to cover? Here you see in this indemnification, the indemnitor is going to indemnify the customer against claims arising out of or relating to any claim by a third party alleging infringement of any intellectual property right with respect to the software. Tip number one is to use those four fundamental principles that we just introduced you to determine what those claims should be. And here we have one example that we thought was appropriate, which is IP infringement. The second tip is that if you are in fact limiting the indemnification to third-party claims, you really want to say that in the contract. When courts construe contracts of indemnification, they will typically say that indemnity is thought of as being related to third-party claims. But if you don't tell the court that was your express intent, they will not necessarily go there for you. So if you're trying to limit the scope of the indemnitor's obligation to third-party claims, you really want to say that expressly in the contract. Our fourth tip goes to the obligation of the customer to give the vendor, the indemnitor, notice of the claim and to cooperate with them in the resolution of the claim, and most importantly, to give the vendor the right to control and direct the defense or settlement of the claim. This is a very important clause for you as the vendor. You must maintain control of the indemnity. You are obligated to pay for the defense, and you are obligated to pay for those damages. So you do not want to separate that obligation to pay from control over the suit. You don't want your customer to be able to go off and settle that lawsuit and turn around and stick you with the bill. So the vendor tip here is make sure you maintain control. And the second tip is to be careful if the customer asks to modify your right to control the indemnification with the language which says something like, well, you can control it, but we as the customer get reasonable approval over counsel that you choose. Or we as the customer get to tell you not to use certain counsel if that counsel conflicts with us and our other dealings. This is really problematic language for you as a vendor, and you really need to avoid it. You really need to make sure that you have absolute control over the indemnity if you're going to sign up to defend the claim and to pay the damages. Tip number 5 goes the other way. So now we're the customer. We've just given the vendor the right to control the defense and settlement of the claim. The tip for the customer is to make sure that you can be aware of what's going on during that process, and importantly, that if the vendor does in fact settle the claim, that they've really taken care of the problem for you. So you do that by doing two things. One is you ask for a right to participate in the claim, even if passively, and you get a right to approve any settlement if that settlement doesn't fully release you from liability. So here you see language which effectuates that. It says the vendor will not settle the claim without the customer's prior written consent unless that claim fully releases the customer. And it also says that the customer may participate in the defense using its own counsel at its own expense. Tip number 6 goes to what we call the remediation clause for IP infringement. So in an indemnification, in a software license agreement for intellectual property infringement, you will typically see a clause, and as a customer and also as a vendor, you really want to have a clause that says, if for some reason the customer's use of the product is enjoined or is likely to be enjoined, meaning a court order is about to be issued stopping the customer from using the product, the vendor has to do something about that. They either have to, and as you see the language here, substitute for that software substantially similar non-infringing software, procure for the customer a right to continue to use the software. So in essence, buy a license so that from the party claiming infringement so the customer can continue using the software. Or if the vendor tries but can't do A or B, then the vendor, or we would recommend the customer, either party can then terminate the contract and get the license fee back, or at least a pro rata portion of the license fee. So the tip here for you as a customer with respect to this remediation clause is to first make sure that the vendor actually has to go through those steps. So you see here the language, and we have the language, the word will there in bold. We think this language, if you're a customer, should read, vendor will substitute for the software or will procure a continuing right for the customer to use the software. And then secondly, you want to make sure that you as the customer have a right to terminate. So if the vendor can't work around the problem or procure you a license, then either the vendor or you as the customer, and we have the language here again in bold, may terminate the agreement. And as I said, in that case, there's typically a refund back of the license fee, either the entire license fee or a pro rata amount. Our final tip for drafting indemnity goes to that all-important sole and exclusive remedy clause, the very last clause of the indemnification. And this is particularly important and applicable for intellectual property infringement claims. Our tip to vendors is that they should make sure that if they are in fact indemnifying for intellectual property infringement, that it is absolutely clear that the indemnity is the customer's sole and exclusive remedy for those types of claims. We think in this case that indemnity is a trade-off. Each party is agreeing to forego certain rights in advance in exchange for certainty of what's going to happen when that claim comes in. The customer is foregoing its right to sue the vendor for breach. The customer is agreeing, look, if I get sued for infringement based on using your software, I will agree my only remedy is for you to defend that claim and pay those damages. So the customer is foregoing the right to sue the vendor for breach. The vendor is foregoing a right too, which is to require the customer to prove that the vendor really was responsible for that claim and should have to defend and indemnify against it. So each party is giving something up here in exchange for certainty, but we don't think it makes any sense for you as a vendor to make the promise to indemnify unless you know that is in fact going to be all of your obligations in the event that claim arises. Okay, so now let's talk about the interplay between indemnity and limitation of liability. Inevitably, in an enterprise agreement, when you are negotiating indemnity, the issue will come up when you get to the limitation of liability of how we're going to treat the indemnity. We just spent all this time and energy thinking about when indemnity is appropriate and how to draft the clause. And now as the customer, I'm saying, look, I want to make sure that those indemnification claims are not capped under the limitation of liability, just like any other liabilities arising under the agreement. So, as I said, the parties will often exclude indemnity from the limitation of liability. There may be a cap on those claims or no cap at all, but there's always a negotiation around that. The tip we want to give you today is what to do when the customer asks to exclude those indemnification claims, not only from the overall liability cap, but also from the consequential damages waiver. So what do I mean by that? Well, here's a typical limitation of liability clause from a software license agreement. You can see section 7.1, we have our consequential damages waiver, and 7.2, we have our overall liability cap. So the customer is asking to accept indemnification claims from that liability cap, but they've also asked to exclude those claims from the consequential damages waiver as well. As a vendor, how should you think about this customer request? Well, as a vendor, you might be concerned with this request because you're afraid it might put you on the hook for these direct losses that the customer suffers. You're worried that in addition to having to defend that claim and pay those third-party damages, you may also have the customer knocking on your door and asking for reimbursement of other losses it suffered related to that claim. So as a vendor, how do you mitigate this risk if you get the request from the customer? Well, we think there are two things you need to do. The first is to use that defend and pay damages structure I introduced earlier. So use the formulation that says, as the vendor, you will defend the claim and you will pay all damages arising from the claim, as opposed to using the broader formulation of defend, indemnify, and hold harmless. Secondly, we recommend in the limitation of liability clause itself that you make clear that the exception you're creating is really only for amounts payable to third parties under the indemnity clause. So what does that look like? Well, it looks like this. You would simply say in that consequential damages waiver that we're accepting amounts payable to third parties under this clause. And obviously you'd do the same thing under the liability cap below. Now, how does this look from the customer's perspective? Let's say I'm a customer asking for this carve-out from a vendor, and the vendor absolutely refuses to make the carve-out from the consequential damages waiver. What do you do in that case if you're the customer? Well, as a customer, this is going to make you nervous, right? Because you're concerned now that amounts that might be payable under that indemnity are now going to be capped or excluded. And you should be concerned because it turns out that characterization of these damages between direct or general damages and consequential or special damages is very tricky, and different courts take different interpretations. And in fact, lost profits, which are a key factor in most intellectual property infringement claims, can be categorized as either a direct damage or as a consequential damage. So knowing all this as the customer, what do you do with this vendor who's absolutely refusing to carve out the indemnity claims from the consequential damages waiver? Well, in this case, as a customer, you should make sure that any amounts payable to those third parties through the indemnification are going to be part of the carve-out no matter how they end up being characterized. So in essence, you're saying we're going to go ahead and treat any amounts payable under the indemnity as direct damages. So what does that look like? Well, again, because the vendor's not allowing us to change 7.1, we're dealing with this in 7.2, but we're going to add a statement along these lines to 7.2, the overall cap that says, for clarity, section 7.1 shall not limit or exclude any amounts payable to third parties. And now this language is important, whether it's attorney's fees, as damages, or in settlement, or otherwise, under section 9. So what we're doing is in essence between the two parties agreeing on how we're going to characterize those damages arising under the indemnification. And we're going to characterize them as essentially direct damages and therefore within the exception. Okay, last topic. We've talked about the mechanics of how you would make an exception from the limitation of liability clauses for indemnity claims. But the $1 million or maybe more question, of course, is should there be a cap on these indemnity claims overall? Well, this is really going to depend on of course, your particular circumstance, who the vendor is, who the customer is, what the technology is, and a number of other factors. But we think there are some common things you should consider across all those situations. The first is that if you, as a customer, are going to agree that the vendor is going to have a cap on their liability for indemnity, you really need to think about whether that should be an overall cap or a per claim cap. And I mean that by per type of claim. So you might well think about a cap on an IP infringement claim very differently than a data breach claim. As I mentioned before, it's not uncommon for data breach claims to be capped. It's less common, perhaps, or it's less justifiable, perhaps, for an IP infringement claim to be capped. Likewise, as the customer, you really want to think through this question of attorney's fees. Are attorney's fees going to be included in whatever this cap is that you're agreeing to with the vendor? If they are, you might find yourself in a situation where the cap is actually being consumed by the attorney's fees, so that by the time the matter is concluded and by the time the damages are to be paid, there isn't a lot of money left to absorb the damages. So here, as a customer, you might want to consider, if you are going to agree to a cap, telling the vendor, look, I'll agree to cap your overall liability for indemnity, but we're going to keep attorney's fees out of that. You're going to pay all the attorney's fees, and then you're going to pay damages up to a certain agreed amount. And finally, as a customer, you really need to think about what's going to happen if the cap is met. And what's going to happen is you, as the customer, are now going to be assuming damages for a claim that you agreed in advance with the vendor was really the responsibility of the vendor. So you really need to think through what that might look like for you as a company, and how you're going to explain that internally or to your board or shareholders if you are agreeing to a cap on indemnity. Okay, last point I want to mention is that within that tool that you've downloaded, you have checklists. Those indemnity checklists cover all elements of the indemnity clause. They do that from both the customer's perspective and from the vendor perspective. And you'll see some items mentioned in there that we didn't get a chance to cover today. So for that and for other issues, such as, for example, the different types of intellectual property infringement claims, or how to deal with exclusion language in an indemnification clause, we'd like to invite you to attend one of our roundtables. We can run through those checklists. We can answer questions you have about today's episodes. And like I said, we can also address other areas on those checklists that you might have questions about. Since we initially recorded this episode, we've had the opportunity to hold a few roundtables. So now I'd like to share with you some of the initial questions and answers from those sessions. Our first question comes from the section on when to indemnify and applying the 4 fundamental principles. And the question is, could you please break down indemnity by type of intellectual property? As you will recall, we concluded that intellectual property infringement was a good candidate for indemnity. This was because it's reasonably foreseeable that a third party might sue the user of a software product or SaaS service for infringement. The vendor is most likely to be responsible for and is best positioned to defend the claim, and no better alternative mechanism exists to deal with the problem. But should we think about this the same way for all types of intellectual property? Let's start with patent infringement. Patents protect inventions, and patents are, by some measure, the most prevalent type of IP infringement claim for software and SaaS. Note that because patents convey the exclusive right to use, both software and SaaS users may be at risk of a claim. Damages for patent infringement can be very high, and given the open-ended nature of how patent damages are calculated, hard to estimate in advance. But for vendors, there's an interesting catch when it comes to patent claims. A vendor's product may be found to infringe a patent even if the vendor has never heard of the patent or done anything intentional to infringe. This combination of a potentially large but hard to measure risk with what some vendors feel is a lack of fault for patent infringement claims will often lead vendors to seek to limit their exposure in at least 3 key ways. First, because patents are issued country by country and different countries follow different standards, vendors will often seek to limit the geographic scope of the indemnity to either just the US or the US plus a smaller set of foreign countries where the vendor actually has a presence or at least some feel for the patent situation. Second, vendors will seek to cap their liability for patent infringement claims, again on the theory that in this day and age, the risk of patent infringement is inherent in the use of any software or SaaS product. In other words, vendors argue patent infringement claims are like the weather and therefore a risk that should be shared, at least in part, between the parties. Third, vendors will focus on the exclusions from indemnity and in particular, the exclusion for combinations. Vendors only want to be responsible for their own products. They do not want to assume liability for claims arising at the connection point between their product and other software, hardware, or services. Customers, of course, will want the vendor to cover the combination of their product with any other technology reasonably necessary to use the vendor's product. A final note here. As a customer, watch out for language that says you are indemnified only against claims arising from patents validly issued or issued as of the effective date. Both of these limitations are problematic. Invalidity is a standard defense in patent infringement claims, so the mere fact that the vendor may challenge validity should not preclude your being indemnified. Likewise, the vendor should be on the hook regardless of when the patent in question happened to issue. Now let's look at copyright and trade secret. Copyright infringement requires either direct proof of copying or proof of access to the copyrighted work and substantial similarity between the two works. Likewise, to be liable for misappropriation of trade secrets, you must know or have reason to know the information in question was acquired or disclosed by improper means. Because fault is more clear with copyright and trade secret, caps are harder to justify, and vendors often agree to unlimited liability. One additional point. With respect to copyright in particular, it's not uncommon for the scope of the indemnity to be limited to claims arising in countries signatory to the Berne Convention. Copyrights, like patents, are issued country by country, but in the case of copyrights, the rights can be enforced across borders if both countries are participants in the Berne Convention. Trademarks protect brand names, logos, and other identifiers of the source of a good or service. Trademark is fundamentally a consumer protection law, and while it's often lumped in with other intellectual property rights for purposes of indemnity, trademark infringement claims are unlikely to be a problem for software or SaaS customers. With that said, trademark indemnity becomes very important if you are reselling or marketing a vendor's product, a topic which merits focus beyond this presentation. Finally, we get to the right of publicity. The right of publicity protects the use of an individual's name, picture, voice, or other likeness in a commercial context. There is no federal statute for the right of publicity. Each state has its own laws. Also note that while there is a growing trend to conceptualize the right of publicity as a form of IP, it also contains an element of tort. For these reasons, if the right of publicity is at issue, you want to be sure to reference it expressly. For example, if you're a customer procuring digital advertising content, which includes pictures or videos of people, make sure the IP indemnity includes an express reference to the right of publicity. And if you're a vendor agreeing to indemnify for the right of publicity, make sure that you get an actual waiver or release from each subject whose likeness is used. Standard copyright assignment or license language may well not be enough to extinguish right of publicity claims. Our second question is also on the topic of when indemnity is appropriate, and this participant asks, what about a request for indemnity for violation of laws? Now, this is not an uncommon customer request, so as a vendor, how should you respond? Applying the four fundamental principles suggests violation of laws is not a good candidate for indemnity. The analysis is basically the same as for breach of contract. The nature of the third-party claims and responsibility for the claims are hard to predict in advance. and it may be hard to connect the violation of law by the vendor with the third-party claim against the customer with any degree of certainty. And finally, assuming the agreement contains a compliance with law's representation, breach of contract represents a better mechanism for addressing the problem. With that said, if the customer persists and you are considering granting this indemnity, then we think context becomes very important. You should really focus on exactly what is meant by compliance with laws. Are you referring to compliance with laws in the operation of your business generally, or are you saying that your product will somehow comply with laws? If this is the second, be careful. This can be very tricky, particularly with SaaS. If the product transmits or processes data, the vendor may be inadvertently making a promise about compliance with domain-specific rules such as HIPAA for protected health information, GLB for financial data, or even the EU Data Directive governing collection and transmission of personal data within the EU. If you are a vendor in this situation, we would suggest you start by asking the customer exactly what they are concerned about and working backwards from there. It's possible you will be able to identify one or more particular laws which are appropriate subjects for indemnity, but we would be careful about leaving it more open-ended than that. Our next question comes from part 3 on how to indemnify and the indemnity drafting tips. And the question is, what's the difference between arising out of and relating to? This language arises in the first part of the indemnification clause. It says, vendor hereby agrees to defend, indemnify, and hold harmless company from and against any and all losses, liabilities, costs, expenses, and damages arising out of or relating to any claim by a third party alleging infringement of any intellectual property right with respect to the software. The tip here is that courts may read these phrases to have different meanings. Arising out of implies causal connection, whereas relating to may signify a broader, less proximate relationship. Because courts differ in their interpretations, we'd advise customers to seek to use both phrases. On the vendor side, we would set arising out of to be your default approach, but if you must concede on this, you can still limit the scope of your indemnity by focusing on the indemnity structure, as we discussed before, and of course, the types of claims allowed. Next, a participant asks, how important is the phrase provided that in the notice, control, and cooperation clause? This language follows the provisions we just discussed and reads that the customer will indemnify provided that vendor will have received from customer prompt written notice of such claim, the exclusive right to control and direct the investigation, defense, and settlement, and all reasonable necessary cooperation of customer. The provided that language is in fact very important because it seeks to condition the vendor's indemnity obligation on the customer performing these actions. Another way to accomplish this would be to say, as a condition of the vendor's obligation, the customer will provide the notice, control, and cooperation. Removing this phrase invites a court to view the notice and control obligations as mere covenants, breach of which would not excuse the vendor from having to indemnify. So, as the party granting the indemnification, you have good reason to keep this conditional language in. Our next question comes from the discussion in Section 3 of the interplay between indemnity and limitation of liability. Do you have an example where a court denied relief because a claim was not carved out of the consequential damages waiver? Here are the provisions in question, the consequential damages waiver, and the overall liability cap. As you will recall, we suggested that customers will likely seek to carve indemnity claims out of both provisions. This is because characterization of damages can be tricky and inconsistent. And this is particularly true for IP infringement and data breach claims, where the issue of consequential damages will almost always come into play. Here's an example carve-out from the liability cap, and here's the carve-out from the consequential damages waiver. Now to return to the question. What if you don't make the carve-out from Section 7.1? Well, we have a 2016 11th Circuit case of interest on this point. In Silver Pop Systems versus Leading Market Technologies, the court refused a customer's claim for damages against a SaaS provider for alleged disclosure of a confidential email list through a data breach. And they did this because neither data breach nor breach of the confidentiality provisions were excluded from the consequential damages waiver. The court found that data breach damages were best understood to be consequential damages, and since those had been disclaimed, the customer wasn't entitled to recover anything for the data breach. While this case didn't involve indemnity, as a customer, you may not want to take the risk that a court will deny your indemnity claim for data breach just because you failed to carve the indemnity itself out of the consequential damages waiver. We would suggest you avoid trying to predict how a court will characterize damages, and instead, if the vendor has agreed to indemnify for IP infringement or data breach, make exceptions to both the liability cap and the consequential disclaimer. This does not mean, by the way, that the exposure cannot be capped, but just that whatever amount is being excluded is excluded from both parts of the limitation of liability. Finally, our last question is about the tool for this episode, and this participant asks, could you please walk us through the indemnity checklist? Well, the first thing you want to note is that there are two different checklists, one from a customer perspective and the other from the vendor's perspective. Looking first at the customer perspective checklist, you will notice in the top section that we suggest the customer ask for the defend, indemnify, and hold harmless litany, that you make sure all types of losses are covered, and that you avoid any language which would limit your recovery to amounts finally awarded, as that could mean you are waiting until an appeal is resolved before your damages are reimbursed. Next, we remind you to make sure that any settlement provides a full release for the customer and to reserve a right to participate in the defense. When it comes to which claims should be covered by the indemnity, we provide an expansive list, but as we have been discussing today, you should expect the vendor to seek to pare that back. The last section here deals with the mitigation of infringement claims. In the event there is an infringement claim and the court orders the customer to stop using the product, or the vendor thinks such a result may be likely, the vendor will be required to try to either acquire a license to the allegedly infringed IP or provide a substitute non-infringing product. As a customer, you want to make sure the vendor has to actually try to accomplish this mitigation before they can terminate your license. And you want to make sure that if the vendor does ultimately fail to procure a license or provide a substitute product, you also have a right to terminate. The next checklist is from the vendor's perspective. Since that's the view we've taken for most of this presentation, I just want to point out a few points we have not yet covered. Under exclusions, in addition to modifications, combinations, and unauthorized use, we propose you also consider excluding claims arising from customer-provided material, third-party code, or deliverables created in accordance with the customer's specifications. One other new topic here is admissions or settlements made by the customer without the vendor's consent. Either one can be deeply problematic, and as a vendor, you should consider adding a clause stating that your indemnity obligations are terminated if the customer takes such actions. And that wraps up the first set of questions and answers from our first indemnity roundtables. Well, I'd like to thank you very much for joining us for this episode on indemnity. I'd like to invite you to participate in one of our roundtables, and we'll hope to see you soon. Thanks.